Okay, it is Monday, October the 7th, and it is 8:30 p.m. Central Standard Time. And welcome already to week 2 of constitutional law. And you know my name, Richard Wright. And after this week, we'll have 4 more weeks to go, and the quarter will be over. So the quarter does move pretty fast, and I do encourage you to get your assignments in on time. And I am going to respond. Many of you, or several of you, or at least, have reached out to me about the initial assignment, the preamble, and I stated in the open house that I was going to be relaxed when it came to APA on this assignment and this assignment alone because of the shortness. Also, I wouldn't enforce the 2-page requirement, but I did want you to make sure you followed the instructions. And as you could determine from those I've graded, I will be grading those assignments starting by tomorrow, and they should be completed by the end of the week. I point out to you that the assignment did require you to write a contemporary version. In other words, rewrite the preamble the way it would fit. So you should have the original preamble in there, and then maybe a reference, a citation to that, where it came from, and then write your version of what you would do to elaborate on it and explain why you would do that as well. And that's the ones who got a perfect score in terms of the assignment. So you make sure, though, that you do follow the rubrics, especially from this point on, especially with the page length, especially with the APA requirements, and make sure you run your papers through Grammarly as well. So I'm going to go ahead and get started. I'm going to share my screen. As you recall, last week, the assignments, we covered a little bit of them, but today we'll cover them a little more in detail. Then I'll talk about the topic of the week. And again, I remind you that your course home is where you can find a lot of good information. I'm not going to go over that again, but I am going to talk about what you have to do this week, briefing a case. Now, I am going to provide you with some material that I have, email it to you after the lecture today that gives you some help with briefing a case. So you need to make sure that you include all of the elements when you brief a case. And it tells you all the way down to here. That's very important. And then make sure you have APA citations. So I'm going to talk about that again, but then I will be providing you, again, something to help you. And this is the first week that you have the Fourth Amendment course project, which you will have weeks 2, 3, 4, 5, and 6. So you'll have it every week now. So you're going to select the topic that relates to the Fourth Amendment. And then you're going to write about that, explain why you chose that topic, and you're going to satisfy the page requirement. And it'll tell you what the page requirement is in the module when we come to it in just a few minutes. So those are the assignments for this week. And then we go on down, and I remind you that lectures now take place on Monday. You remember last week we did it on the 1st. And the reason why we did it on the 1st is because of the fact that you started your classes on the 30th, of September. So September 1st is when we had our lectures, and that was a Tuesday. So now, though, your lectures are on Mondays. So weeks 2, 3, 4, 5, and 6 lectures will take place on Mondays and last until 9:30 or less. And then you know about the keyword. Then, of course, under recordings, you will see this is one place where it will say week 2 lecture and then the link. And you can open up the link if you want to look at it. So pay close attention to that. So now let's go over and let's take a look at the announcement for the week. All right, so we're at week 2. So let's look at this announcement. Equal protection under the law will be the topic that we'll be covering, and that is covered in your reading in Chapter 4 and Appendix E of Constitutional Law. I provided you with the PowerPoints for Chapter 4 that you should have that will coincide with the reading. And then we're going to discuss equal protection under the law and briefing a case. And of course, reminds you too that lectures are on Mondays now, and again it gives a link here as well. And then your discussion assignment. Your discussion assignment is it really equal? And it addresses the Equal Protection Clause. And then the second one is prisoner equality, about prisoners filing lawsuits and things of that nature. And many of you have started to provide those. So both of those posts are due, initial post tomorrow night, October the 8th, and then your reply post is due Saturday, which is October the 12th, 11:59 p.m. Central Standard Time. Finally, your written assignment, briefing a case, and the Fourth Amendment project. Those are the 2 assignments that you have that I mentioned a few minutes ago. Of course, they're due this Sunday, which is the 13th, and the requirements are found in the Blackboard under the Lessons tab and the rubric, which we just looked at just a few minutes ago. And then you know what my motto is all about, because I gave my lengthy story about my life to get you to understand why I'm the way I am and why I require perfection of criminal justice students, and ultimately hope that will pass over to you being really good as a professional as well. So let's look at the course calendar real quick. Here we are here. And the course calendar, this is where we are today. Your reading assignment, and you click on it, then you save it, and then there's the initial posts that are due tomorrow night for each one, and the reply post that's due on Saturday the 12th, as I previously stated. And then your written assignments are due on the 13th, along with the keyword that I will give you as well. And then again, we start all over again, and notice that we go all the way through until you get to November, when this course ends November the 5th. So it ends November the 10th. I stand corrected. November the 10th is when the course ends. So you will be aware of that. All right. So if you pay attention, you'll notice you'll have full 6 weeks due dates. Here's 1, here's 2, here's 3. Here's 4, here's 5, and then this was last week, which was 6. So all the way until the 10th of November. So that's it for the course calendar. It's always there, so don't be confused that the course ends on that following Monday. It ends that Sunday. All right. So now let's get into our topic for the week, which is equal protection under the law. So again, let's take a look at the assignments. I've already shown you the rubric, and then if you clicked on this too, it'll remind you of the due date. There's your due date right there. For a possible 100 points, this is what you're going to do. You're going to look up in the Fourth Amendment your text in the internet, review cases and some other sources. And after you have extensively reviewed the amendment and the law, pick an area within the Fourth Amendment that you'd like to research further. Now, remember, this is what you're going to start your project with, and that after that. Okay, there are several things under the Fourth Amendment. Don't try to write about more than one. Trust me, it's plenty on each of them. A one-page paper indicating that you've chosen why you chose it, and then make sure that your spelling, punctuation, and make sure you satisfy the APA requirements that I set out in the rubric. But it tells you the page length right here, and it tells you what you need to do, which matches actually what's in the rubric. And that assignment is due on the 13th, Sunday. Let's go back. Even if you don't click on that, you see the same information here. Okay, and make sure that it is a Word document. If you submit a PDF document, you're going to get a 0. All right, so that's the first of the 2 written assignments that's due Sunday. The second one, you're going to brief Terry versus Ohio. It's an extensive case, and you're going to follow the directions given in briefing a case. And so where are you going to find that? I'm going to show you in a minute, but then I'm going to send you something too as well. So make sure you look at that. And that's going to be found under the Lessons tab, and I'm getting ready to provide that information to you. So you're going to properly brief a case. Make sure you have a cover page, and as a result of that, you want to make sure that you do it properly. Now, you don't have to have references, because the case itself, as you brief it, but you're going to, and you don't have to worry about that reference page in this instance, because of the kind of assignment it is, but satisfy all the elements that the rubric asks for. And then you got your 2 discussion posts that I've already discussed, and then your live classroom lecture. Okay, so it's pretty clear what you have to do. 1 page here, and then your briefing should at least take a page as well, at least. But the case you're going to brief is Terry versus Ohio. Now, this is the appropriate way to cite a case. This stands for, just so you'll know, if I look at this, it tells me first the name of the case. It tells me what volume that I could find it in the United States Supreme Court books. And it tells me it's at page 1 of that. And it tells me the year that the case. And that's the proper citation method. And that's what I'm looking for you to use throughout this course when it comes to cases. So now let's go and let's get right into the lesson content. Now, and I already told you what the reading was and so forth. And we're going to discuss equal protection under the law and how to brief a case. And then again, I'm going to send you some information. And Module 2, the course, Module 2 course project, you already have the information that I gave you concerning that. Of course, your written assignment, briefing a case, and then your 2 discussion posts. Okay. So now let's go on down here. So the 14th Amendment, which is this. Oh, they took it out. I don't know why they took it out. It's not found anymore. But they have it cited here. But the 14th Amendment, oh, I see why, because they added it down here. The 14th Amendment Section 1 sets forth that all people should be treated equally under the law. And that's the essence of the Equal Protection Clause. You should not be discriminated on the basis of race, religion, sex, national origin, or any shape, form, or fashion. In other words, and it also dictates something that it really still operates unequally, is that you should have the same kind of access to attorneys, and you should have the same quality of attorneys, whether they are appointed by the court or whether they are public defenders, as a person who is able to get a dream team like O.J. Simpson, or as you know, that people who have a lot of money, they are able to get top-notch attorneys. And so the point of the matter is that you should be treated equally. And the scales of justice, if you ever see the scales of justice, and Lady Liberty, let me see if I can pull it up to show you. Scales, let's do a little justice. Okay, image. Okay, which is basically the statue. So I want to show you so you can see it. Okay, now, I wanted you to see it. It's based on scales that are saying the scales of justice relate to the fairness which is supposed to take place in the judicial process, indicating that each side of a case will be considered in a court case. And additionally, the scales underscore the decision to be made by weighing the evidence in a fair manner. As you know, in criminal cases, it's beyond a reasonable doubt. In civil cases, preponderance of the evidence. The sword symbolizes Lady Justice's authority, the authority to make the decision. And justice is blind. I'm going to see if I can make this bigger so you can see this. Okay, you can see the statute right here. And you see this is pretty much justice. She's wearing a blindfold, and she's holding the scales of justice, which are supposed to be equally balanced here. And she has a sword, as I said, which gives authority for Lady Justice. And so it's an illustration, an example. I used to have one in my office when I had my law office. So I just wanted to show you what it looks like, and you can see it in a bigger. So the scales should be equal. Now, what usually a lot of people say is that money gives you more weight in terms of it. Top-notch lawyers and the same. However, though, the trier of fact, whether it's the judge or the jury, should operate with the scales the way they are here. Now, in reality, I understand what many of you are thinking as you look at this and say, well, that's not really how it is. And I have to agree with you. Unfortunately, as I was saying to someone, that there are too many people who are actually in positions of authority in making these decisions that don't follow the scales of justice. Now, be aware of the fact that justice is blind. So what gives justice vision is the individuals, the people, as I said, in judges or jurors, male and female, to determine what's honest and fair, and to balance it all together. So you should be aware of what the symbols are all about. And I've already told you all of that. Okay. What does the balance scale mean in the law? Again, the most ancient symbol associated with the law is the scales of justice, symbolizing impartial, deliberation or weighing of two sides in a legal dispute. The scales are found throughout the buildings like the Supreme Court and places like that. So I wanted to share that with you at the outset as to how equal protection of the law should be applied, and the foundation is the Constitution, but the symbol of that is the scales of justice as well. So it says here specifically, all persons born or naturalized, which means that if you are born in the United States or you're naturalized, which means you can, by immigration process, become a citizen of the United States, and subjects of the jurisdiction thereof are citizens of the United States and of the state. So the United States as a whole and the state in which you reside. So it's United States of America, and I'm in Illinois, which is my state. No state shall make or enforce a law which shall abridge or the privileges or go against the privileges or immunities of citizens of the United States. Okay? Nor shall any state deprive any person. Notice what it just said, any person. So that means you could be a non-citizen. So as long as it's a person, of life, liberty, or property without due process of law. And what that simply means is that in all cases, whether it's civil or criminal, denying a person of life is, of course, the death penalty, right? So it doesn't say that you can't deny a person of life, but it says you have to have due process of law. And what that means is that there must be a fair hearing, as I've just discussing already, that determines the issues, and it is determined based on the standards, depending on the kind of case. Again, if it's a criminal case, beyond a reasonable doubt, and or if it's a civil case, preponderance of the evidence. Now, let me talk about beyond a reasonable doubt for a few minutes to you. What most defense lawyers do, and I, being a defense lawyer for many, many years, represented, thousands of cases during those periods. My job was to provide for my client a doubt. It doesn't matter what kind of doubt. Even if it's a little bit of a doubt, then in that case, then it's not beyond a reasonable doubt, and the person should not be convicted. And the more doubt that you plant in the trier of facts, now whether it's the judge or the jury, the more likely that that individual would be set free or found not guilty. Now that's what it means. So that means that you can't just take a person, arrest them, and lock them up. Yeah, you do. You do. But you're locked up, and then you have a right to a speedy trial, which that's set out in another part of the Constitution. And so it's determined whether or not, and that's in the Sixth Amendment, that you have a right to a speedy trial. And a speedy trial is determined based on the jurisdiction itself. But anyway, the truth of the matter is that the law enforcement authorities cannot deprive you of life, liberty, or property without due process of law. That is also why if an excessive force case is brought where law enforcement is involved, then that means then that that person, if they're found guilty of excessive force, could be violating the civil rights laws, depriving a person of their life. But the underpinning comes from this clause, all right? And that the 14th Amendment actually applies and gives legs to the first 10 amendments, the Bill of Rights, in applying those on the state level. So thus it says, and I'm trying not to confuse you, but so you know what it means by not depriving a person of life. So be aware of the fact that when a person is sentenced to death, they will go to what we call death row, and there will be so many hearing and processes and procedures which takes years and years and years and years for a person to actually reach the point where they are executed if they're found guilty and given the death penalty. So liberty means what it says. Liberty means you're free. Well, of course, if you are charged with a crime and that crime subjects you to, even if it's a misdemeanor, it is still denying you of liberty because it will cause you to be locked up in jail. Now, keep in mind, people, I am not talking about when you're first arrested. I'm talking about what happens after you've gone to court and then whatever the result is, if you're incarcerated, whether it's a jail sentence, which is a short term, or a prison sentence, which is long term. And so you can't deprive any person of liberty without due process of law, giving them an opportunity to respond. As a defense attorney, I've presented evidence to say that my client didn't do it, or I've provided information if it's a like a self-defense case where I've raised an affirmative defense where that person had some good reason why they did it, or either they weren't capable mentally of completing that crime, or they were protecting somebody or something. Anyway, the bottom line is, once again, there's a hearing that takes place where all evidence is brought before the trier of fact. And then it says property, which means that property cannot be taken. And that's now we're starting to talk about the civil side of it, where even if you did you not know there are people says, oh, I get my park in the wrong place, I get my car towed, and there's no hearing. Well, you can actually go to court and have a hearing to determine whether or not you get your property back without having to pay that towing. It just takes time. So what people most time do is they just go ahead and pay it. But property cannot be taken away from you without due process of law. Let me give you an example. In criminal cases where the property is used, particularly in drug cases, where the property is based on ill-gotten gains, or you allege that the property is yours and it really is somebody else's, it goes to court, and based on the evidence of a hearing, it's determined whose property it is. But remember, it's still due process of law. Now, of course, if it's a civil case, it's preponderance of the evidence. So, you know, like, for example, forfeiture in terms of assets, which involve a lot of, I did it a lot in drug cases. Well, if a person is guilty of a crime and that property is involved some shape, form, or fashion, whether it was obtained or whatever, it can be taken away. But the standard of proof then is not beyond a reasonable doubt, but preponderance of the evidence. I once represented a couple who had a situation that they were going to have their funds frozen, and they at the same time had a family member who was, I think, either convicted or under investigation, but I think he was convicted of laundering money. He had legitimate businesses, but the funds that he used to get those businesses started were the basis of ill-gotten gains, i.e. selling drugs, selling hot clothing or hot anything, stuff that you hear the term fell off the truck. What that simply means is that someone has robbed a truck, a freight, and then is selling it on the streets. And that could be meat, That could be clothing, that could be furniture, and other things of that nature. But if that person, for example, even uses a vehicle, and that vehicle is theirs, then it can be taken away because they used it to commit a crime. But what I was telling you is I was representing this couple whose family member was charged with that, and I didn't go to court because we ended up settling outside of court, but we would have. We were heading to court as the next stop is I had to meet with the feds. I believe it was the FBI that we met with. It was either that or Secret Service. No, it was FBI, and I was able to establish that the big deposits that they had in their account had nothing to do with that individual and their family, but instead was monies that they had received as a buyout when they retired from their jobs and were offered early buyouts. So they got that money and put it in their account. And so again, they wouldn't have been able to freeze that money or take that money because of the fact that there was a close relationship they had with the person without establishing that those proceeds had something to do with the ill-gotten gains of their family member. So that's what that means when it says the equal protection clause. That's what you're going to be doing in terms of writing about your discussion post this week. Then it says, nor to deny any person equal protection of the laws. So everybody should be equally protected, as I just said earlier when I talked about that. So now let's talk about some of the processes that take place within cases, and specifically dealing with criminal cases. So as you know, individuals have a right to a jury trial based upon the law and the Constitution of the United States and the cases that are decided thereafter. And so there are two ways to hear a case. You could have a jury trial, which you can waive that right, which means you could say, no, I don't want to do that, but I will let a judge decide. Most of us defense attorneys, like, we have a term we call 12 in the box, which means generally we like jury trials, and we would rather have individuals who are members of their community, who are fair and impartial. And we go through a process of jury selection called voir dire, V-O-I-R, and the second word is dire, D-I-R-E. And what we do is we're able to question those individuals about their ability to be able to be fair and impartial. We're able to see if they might have some biases, and that we as lawyers can excuse some of the jurors by using what we call peremptory challenges, which means we don't have to give the reason for it. We just decide, but we cannot use and should not use them to remove a person on the basis of race. So it says here that jury selection is the concept of equal protection under laws and how it works in the criminal justice system. And then I talk about that. But it says we can use peremptory challenges, but we do and don't have to state the reason. However, if it's determined in the court based on the Batson versus Kentucky case that a juror may not be removed solely on the basis of their race. Now, most lawyers don't say that, but it can be seen, determined, and argued by an individual sometimes that the jury is stacked based on race. So if the lawyer believes that the other side is removing jurors based solely on race, then they can file a motion and bring that to the attention of the court, and the court will then evaluate it and then determine whether or not that is accordingly that is taking place or not. So the main holding regarding the equal protection under the laws from that case is this, and I'll read it to you, and then I'm going to talk about it. The same protection principles as are applied to determine whether there's discrimination in selecting the veneer, which means the panel of jurors, also govern the state's use of peremptory challenges. Now, the veneer is generally determined from, in most jurisdictions, from registered voters that are at random sent jury summonses, and some jurisdictions use other ways, but most are registered voters in the area or the county where they reside, and or if it's a federal case in the jurisdiction they reside. So it says, in selecting the veneer, also govern the state's use of peremptory challenges to strike individual jurors from the petit jury, which is what we call the jury itself, not a grand jury. That's a different thing. Although a prosecutor ordinarily is entitled to exercise peremptory challenges for any reason, as long as that reason is related to his view concerning the outcome of the case to be tried. But the Equal Protection Clause permits the prosecutor to challenge jurors solely on account of race, on the assumption that because that a black juror as a group will be unable to impartially consider the state's case against a black defendant. And the opposite works in a black defendant if it's the jury is primarily white, and then blacks are struck by the prosecution instead. So that's the holding essentially in the Batson versus Kentucky. When we say holding, and you'll see that when you briefs, it means that's the main idea of the actual case in layman's terms. And so at this time, Batson has not been extended universally to age, gender, or religion, but they're moving in that direction, I can tell you that for sure. So that's how jury selection works. And then we talk about discrimination in criminal justice as a whole. We look at the statistics, and you see the percentages that are listed. It says at mid-year in 2010, whites represented 44% of all inmates, blacks 38%, and Hispanics 16%. I don't know about that. I don't know about that. I don't know about that. And I honestly can say I don't know about that because I have visited many of prisons, many of jails, and the percentage of blacks has been more than that 38%. It's been higher. So I don't know how. You know what? You got to remember about surveys. Who does the surveys and those kind of things? So I sometimes query about the numbers when my own two eyes see differently. I think you all understand where I'm coming from in terms of that. It says, in a survey of 40 urban communities, counties across the state in 1998, 62% of juvenile felony defendants were black. Now, see, now we're heading in a direction more like 20% were white, 16% were Hispanic, and almost 2% were another race. And then, according to Bureau of Statistics survey in local departments across the country, it was found only that 1 in 4 officers were a member of a racial or ethnic minority. Now, that's true. That is something that is starting to change. I remember in Chicago what has happened, and that now more and more minorities are being recruited to get positions in CPD, which is Chicago Police Department. But I will tell you this, that I know and am familiar with many suburban departments, and many suburban departments still have a disparity in terms of minority members of the departments themselves. But departments they say they're committed to racial parity in terms of balancing out their departments. And so there are some smaller suburban communities where you might find one African American. You might find one Hispanic. The point of the matter is that these are realities that we deal with. And so in the urban areas like Chicago, in Detroit, you know, the major cities across the United States, you're picking up more minorities in departments. Chicago is committed also to increasing the number of Hispanics because of the population of Hispanics in the city. And also, there are now, based on some lawsuits that took place, the height restrictions are relaxed as well, because it was discriminating against Hispanics, particularly Mexicans, who were generally shorter in posture and build, and then also women. You're seeing more and more females that are recruited in the departments. So I'm always interested in, you know, more up-to-date information. A lot of things have changed since 2017. I mean, I mean 2007. That's 12 years ago. So a whole lot of things have changed. In data collected from the federal law enforcement agencies, only a third of the federal officers were a member of a racial or a minority in 2004. And this included 17.7 who were Hispanic and Latino, 11.4 who were African American or Black. In 2002, ethnic minority officers consisted of 32.4. I remember when I was a kid in 1969, it was my desire to work for the FBI. And I actually applied to the FBI while I was in high school. There was an investigation done. There were FBI investigators who came to my school, went throughout my community, and I went through the whole process. However, I received a letter not accepting me. Now, that had nothing to do with what I went through in my childhood, but I would find out years later the reason why is because at that time, 1969, the director of the FBI, J. Edgar Hoover, who was a devout racist and sexist, he was summarily dismissing minorities and women from the FBI. I received a letter years and years and years later apologizing for that after it was brought to light that that's what he did during that era for individuals who applied and were rejected. And they tracked me down because the FBI could find you anywhere. And by this time I was in law school, but I wrote back and told them thank you, but no thank you, because I'm done with that, and so I didn't do it. But I'm just saying all this to say that these numbers are still can use some work in terms of minority individuals in these positions. According to the U.S. Justice Department, the racial disparity for judges is extreme. I have to vote on that one and agree. It is changing a lot from the time that I started in 1978. I can tell you that all the way to when I retired in 2000 officially, and since that time when I still follow, you know, the judicial elections. Of course, I vote for them, and then I also pay attention. There are some disparities. For example, in the county that I live in, which is Will County, in the court, there's not that many minorities on the bench. I think it's three. And one was just recently elected. But the point of the matter is that the population in Will County of minorities is far greater than that. So there is a disparity. They talk about 2004 in Wisconsin, there were 240 circuit judges, 229 of which were white, and only 6 were African American, 3 of which were Hispanic or Latino. And so the fact of the matter is that there is a disparity, and this can have an effect on cases and how they're decided. If you look at some of the cases that are decided in Chicago, and you look at judicial makeup, it could have something to do with sentencing even, because in most jurisdictions, the sentence is determined by the judge, in most. I discovered that the Bolton case, where that Geyer, that officer who was found guilty of shooting that young man in Dallas recently, the sentence was not determined by the judge, but it was determined by the jury. But the jury was a balanced jury, and so it came out, as it did. But there are so many instances when it is not. So it says it is important to examine the demographic makeup of the prisoners, the law enforcement, and judiciary, because it gives us some insight into how things work. Okay, and then most of the people that I know who can't afford an attorney end up with the public defender's office. Now, let me make an announcement about that. There are people who don't think that they're real attorneys. I have to tell you, I know public defenders who are extremely professional. But the problem that you should be aware of is that the public defenders have a volume that the private attorneys don't have to take. And not only that, they're not required to move their cases within a certain period of time by their superiors, as is the private attorney. So there are some pressures that the public defenders have that are built into the system that cause them, as some people might look at, as not to do as thorough a job as a private attorney. And then, of course, the other thing is the defense attorneys who are paid privately in many cases can afford to get experts to help them prepare their cases. I had some cases where I had people that had pretty good money, and I represented them successfully, and we got some good experts in there as well. So you think about that in terms of the whole process. So now let's conclude by talking about briefing a case. And one of the skills that is important, and I learned this actually before I went to law school, because I told you that the law firm discovered that I knew how to do legal research, and I taught myself how to research and write memos and briefs. And so what a brief is really summarizing the case and providing some key information, and it is important. Now, when you prepare your briefs, I don't want you to copy from any sources. It needs to be your own words, so that to help you find your case, you already know what the case is that you're going to be using. And so you're going to find your case. Brief somewhere in the internet does not mean that you should use that brief. Do not use a copied brief. I will run it through Grammarly. And if I find out that that's the case, you're going to get a 0. The purpose of the brief is to help you to understand what it is. And I'm telling you already, the entire purpose of briefing a case is lost if you're merely copying somebody else's work. That is plagiarism. All right? So I'm telling you how to brief here, just a little bit, just a little bit. So the title, e.g., Miranda versus Arizona. The citation, I already talked to you about that. Remember, yours is, I think it's Terry versus Ohio. So in the facts, you're going to summarize the facts. Do not copy and paste from another source. I already see how, I'm telling you, I will run it through, and I will see it. Don't say, oh, I know. No. I know, and I have briefed many cases, and I know. List what happened in the lower courts. Just a few details is sufficient, 2 to 3, maybe 4 sentences or something like that. Issues. So the question is, what is the issue or question facing the court? Now, from the issue questions, in the way that they can be answered by yes or no, but I also want you to elaborate on those issues. Now, the holding, I already told you about the holding. Did the court answer the issue questions, yes or no. Now, there are, and then, so we're going to come down. Reasoning. Now, this is the biggest section where you're going to explain the reason why the court's holding is the way it is, and you're going to explain that too. Now, there's going to be what we call concurring decisions sometimes. Concurring decisions, let me explain what that means. Where an individual has voted on the court to agree with the decision, but for different reasons than what the court majority has stated. In other words, for their reasoning is different. The dissenting opinion is just what it says. We don't agree because, and you're going to see that in there. You're going to write in your own words what that dissenting opinion is on about. So only include in this section is you believe that concurring or dissenting is important in some way. Now, I will tell you this up front. Don't dismiss the concurring or dissenting opinions, especially dissenting opinions. There was a case that was decided years ago that was Plessy versus Ferguson. And Plessy versus Ferguson was a case that stood for the proposition that it was okay to have individuals have separate facilities, restaurants, and to live in, to go to school, and that Caucasians and African Americans should not go to school together, and all those different things. However, in 1954, in a case, famous case, Brown versus the Board of Education, the United States Supreme Court reversed Plessy versus Ferguson. And so what I'm trying to say to you, in the Plessy versus Ferguson case, there was some dissents that kind of indicated that why it wasn't good. Those dissents were used to give strength and power to the successful argument of Brown versus the Board of Education. The lead attorney in that case was a gentleman who would later become the first African-American Supreme Court Justice of the United States, Thurgood Marshall. So that's a little bit of history and information for you. So I'm saying to you that as a law student, and I learned this before, the importance of concurring and dissenting opinions. There are people who skip over them all the time, and they don't know the value of them. So that's how you brief a case. Make sure you have a cover page as well. I'm going to, again, send you some more information emailed to you after the session today. And so finally, the Fourth Amendment course project, about the Fourth Amendment, you're going to take the Fourth Amendment apart, and you're going to decide what areas that choose one aspect and address the case, use the case law, and let that be you a specialist in that area, such as the Terry stop. And I won't comment on about what that is. A search incident to an arrest. Exigent circumstances, probable cause, and then public school searches, etc. But there are so many areas. There's a myriad of areas. So now, your final project is due in week 6. Now, each week where it's bold, that's when there will be a written assignment, okay? So week 2, you just have an introduction to the topic, all right? So you're going to select that information, and you're going to provide that. Week 3, case law and secondary resource. And then week 4, week 5, and it tells you what you're going to do concerning it in the final project. All right. Now, what I usually tell students is each week that you do, and I actually, to be honest with you, I don't know why 2 is not bold, because it really should be, because there is an assignment on the timeline. There is an assignment for week 2 that we already have covered. So you're going to select your topic. based upon the requirements that are set out in the written assignment, and you will be graded for that. Then week 3, we'll talk about that. So now what I'm trying to tell you is this: save what you accumulate in week 2, in week 3, week 4, week 5, and then add that into with topic headings such as topic selection, boom, 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 and what you had to do in that week 2. Week 3, case law and secondary source research, you're going to include that in there. Current topics that relate to the area that you selected, interview, and we will deal with that when we come to week 5, and then week 6, we'll have the final project. So it says you must choose an aspect of the Fourth Amendment, research the law, and it's telling you basically discuss a relevant event or case, and after your opinion of the law in its current state. You could talk to a judge, a state's attorney, a police officer, a public defender in your area, and interview them. That's where the interview comes in regarding the Fourth Amendment issue, the issue that you selected, not issues. To focus on the use of that, and then use this interview as a secondary source throughout your paper. That's what I was telling you a few minutes ago. All right. So you need to contact and schedule an interview early enough before so you can get that done. That's the only thing that you have to do outside of class. And it should be, your interview can be completed in person or over the phone. Your final paper in week 6 should be 6 to 8 pages long, not including the cover page and the reference page, and follow APA. And you'll need to submit a cover page and reference page using APA format. Now, 6 pages at a minimum. 8 pages is a max. I've had students who go beyond 8. I don't punish you. There are some people who have wrote some very good papers. Be aware of what it says here. Each of these assignments is evaluated and graded independently, which means that you'll get a grade for week 2, week 3, 4, 5, and 6. All right? And then your week 6 is actually the compilation. So, all right? And I've already provided grading criteria because of the rubric and so forth and so on. If you have any questions, reach out to me. Or either post it in the general course questions. And that's it. I want to go back again just to show you what I was talking about when I said, let's go back to 2. Let's go back to assignments. So you're going to be graded for this. You're going to get how many points? It tells you here. 100 points possible by satisfying that. So really that should have been highlighted as opposed to gray. So every week you have an assignment. So this week you're going to select your course topic and you're going to provide the details that they ask for, at least 1 page, okay? And then briefing the case. So what I want to give you, as I say good night, as we conclude this session. I told you it would be close to an hour or no later than 8:30. So I want to give you a key phrase. And that key phrase is equal protection. That's it. Give me that and you get your points. So with that, I'm going to say good night to you. I will see you next week at the same time. Have a great week, and again, you know what to do if you need any help. Good night.